The next case before the court is State of Ohio versus Melissa Dovala. Each side will have 15 minutes for oral argument, and the appellant may reserve up to 5 minutes for rebuttal. If you wish any rebuttal time, please let me know, and I'll try to give you a hand signal when you are there. You may proceed when you are ready.
Your Honor, with your permission, would you mind if I brought up just a stopwatch up here so I can monitor my own time?
No problem.
Thank you, Your Honor.
And you wish to reserve how much?
5 minutes, Your Honor.
All right.
May it please the court, my name is Sarah Schwegardis, and I'm here on behalf of the appellant Melissa Dovala. This case is not the first time before this court. This is the 5th time that this court has reviewed this case over the past decade. However, this does have a rather complex set of facts and procedural history, and depending on what the court would prefer, I can go through a brief recitation of the underlying facts and procedural history, or simply
It's entirely up to you how you wish to use your time.
Okay. I guess I'll leave it to the past 2 years, and I'm happy to answer any questions about the underlying trial or any of the previous hearings. What has brought us here today is initially a motion for relief from judgment under Civil Rule 60b-5 to reopen the post-conviction proceedings. This was filed 2 years ago, and it was on the basis of the discovery that there was materially misleading and irrelevant substantial information that was provided that we believe influenced the trial court's decision when it denied Ms. Dovala's petition. The primary issue in the post-conviction proceedings was the effectiveness of trial counsel, and specifically whether he failed to adequately prepare for the trial. This was a case where the defendant, now appellant in this case, was a 33-year-old woman with no criminal record, no history of violence. She was the mother of 3 young children and was an experienced daycare provider. And there is also essentially the death of a young child where there's certainly no question that the injuries were first noticed while he was in her custody. And this case proceeded to trial, and the trial counsel did not hire an expert there was no question that the child died of some sort of head injury, or it was likely that the child died of some sort of head injury, and the trial counsel chose not to hire an expert specifically an expert neurologist to address those issues. In the previous proceedings, trial counsel had testified that he had in fact consulted with a neurologist, and that he had consulted with a neurologist 60 to 90 days before trial, that the neurologist specifically agreed with trial counsel's theory of the case, that the cause of death was an inflicted injury where death rapidly occurred afterwards. The trial counsel specifically testified that the expert had access to all the files and that he consulted with him during trial. Finally, he referred to the expert as a Dr. Watson, which in fact we learned later his name was actually Dr. Swanson. This really can't be understated, the substantial misrepresentations and deceitfulness that arose out of the trial counsel's deposition testimony. when the trial court originally denied the post-conviction petition, she did so on the basis that essentially finding that trial counsel was credible, and because he did his best, he was experienced counsel, he consulted with the experts. At the time, Judge Cross then went through and identified everything that he went through and took issue with nothing that he did, and put full stock in everything, despite the fact that there was some conflicting testimony from the defendant, who was his client, from the records that were provided that showed that he had certainly never hired a neurologist, and also from the defendant's mother about what they were told about experts, why they would hire them, why they wouldn't. So Judge Cross found former Judge Burgess' testimony to be completely credible in all accounts, and discredited other testimony, including the testimony of another defense attorney, Mark Devan, who testified that this was an inadequate preparation, and that while certainly he attempted with cross-examination, that there was much more that needed to be done. So this court had initially addressed all of the information that came forward from the initial 60D motion, and remanded it back to now Judge Pokorny to review, because he did not take into consideration additional information provided by trial counsel's co-counsel, Laura Perkovic. And we are here today because we find the trial court's decision was manifestly against the weight of evidence that was provided, and that he simply did not take in, that it was an unreasonable decision because it did not take into account the credibility of former Judge Burge and his testimony. When this court originally remanded this case, it was to specifically determine whether the circumstances surrounding former Judge Burge's statements regarding his efforts to procure a medical opinion in light of the subsequent testimony of Dr. Swanson and Ms. Perkovic inherently affected the accuracy and reliability of the trial court's judgment. Based on Judge Pokorny's trial entry, which found essentially that they referred to Dr. Swanson's affidavit as equivocal, and put stock in Judge Burge's rather offensive comment that the only reason he hired Ms. Perkovic was not based on her experience or her abilities as a lawyer, but simply because she was married to a board-certified neurologist. This is certainly in conflict with what Ms. Perkovic testified to in her deposition, and what Dr. Swanson swore to in his affidavit. None of the inconsistencies were addressed in the order, and we would ask this court to find that the trial court abused its discretion when it refused to reopen the post-conviction proceedings. I'd be happy to answer any questions, otherwise I will reserve my remaining time for rebuttal.
Well, you can only reserve 5 minutes. So
sorry, yes, sorry.
If you wish to,
no, that's.
You have 2 or 3 more minutes on your time.
I'm okay. I'm happy. If you any questions, I'm happy to answer. Otherwise,
well, thank you.
You're welcome.
May it please the court. Good morning, Your Honors. My name is Brett Hammond. I'm an assistant prosecuting attorney from Cuyahoga County, Ohio. We were assigned as special prosecutors on this case. As defense counsel previously explained, this is the 5th appeal of this case. And there's a lot of facts, and I'd like to try to just simplify the issues as much as possible, but no more than necessary to really just bring forth what I think are the critical issues in this case. As defense counsel explained, this case was reversed. It was reversed for really 3 reasons, according to this court's last opinion issued in 2014. First, the trial court applied the wrong standard of law. Second, the trial court did not consider the testimony and affidavits of Ms. Perkovic. And third, in addition to that, it wrote in its order that the testimony of Ms. Perkovic and also Dr. Swanson was merely cumulative, and that wasn't the case. And so for these reasons, this court found that the trial court abused its discretion. It reversed and remanded so that it could apply the appropriate standard of law and properly consider the record before it. What I would simply say is that, first, as an initial matter, the trial court did go ahead and comply with those mandates. It did go ahead and apply the correct standard. It evaluated the accuracy and reliability of whether or not the post-conviction petition should stand. Moreover, in addition to that, it did fully consider the testimony of Ms. Perkovic and Dr. Swanson. I think the real issue here, and the question the court has to ask itself, is that assuming the worst case scenario possible, assuming that Dr. Swanson was actually not consulted or was only minimally consulted, what effect would that have on the case? And I would point out to this court that there was a previous post-conviction petition. That petition was held after the defense proffered and introduced evidence from an expert neurologist, Dr. Please. And after that evidence was introduced into the record and a post-conviction petition for relief was filed, the trial court denied relief. And particularly the trial court noted that even though that doctor altered an alternate theory of the case, it found that that was not enough to affect the outcome of the proceedings, that the outcome of the proceedings would not necessarily be different. That decision, more importantly, was appealed to this court. And this court, in terms of reviewing that evidence, found that the trial court was correct in finding that the defendant was not prejudiced, that even though an alternate theory of the case had been offered, that decision should stand. And so what I would simply say is that even in the most extreme case, regardless of the issues of the discrepancy over the extent to which Mr. Burge actually consulted Dr. Swanson, the key is that that decision, the original post-conviction petition, that decision has not been challenged. I think beyond that, there is competent and credible evidence to support the trial court's finding that the defense counsel in this case did actually consult medical experts. It's undisputed that defense counsel did consult an OB/GYN, pursue alternate theories of the case, particularly the possibility that there was some sort of genetic defect. For various reasons, they decided not to go forward with that theory. Mr. Burge's testimony is that they decided not to go forward with the genetic defect theory because he presented it to Ms. Dovala, and she decided that if they ran medical tests to evaluate whether or not the victim had a genetic defect and those came back in the negative, that would actually prejudice her case more than benefit it. Regardless of the reasons, it's clear that they did consult the OB/GYN. In addition to that, there is competent and credible evidence to support that Dr. Swanson was consulted to some extent. Now, what extent was he consulted? I think that's a little bit unclear, but I think the one way to consistently read all the evidence in the record is that essentially Ms. Perkovic did at some point consult Dr. Swanson. They had conversations, and what's clear from Ms. Perkovic's testimony and her affidavit is that she did say that at some point he said, this is a brain trauma, this is a brain injury. And that information was ultimately relayed back to Mr. Burge. So he did have that information, and the problem was there essentially were no clear alternate theories, no alternate defenses to the case.
What do we make of the affidavit that, or I guess it was initially the deposition testimony that misidentified the expert? As not Dr. Swanson, but Dr. somebody else.
Right, is Dr. Watson, I think, rather than Dr.
Yes.
Swanson.
Yes. Because the position
Right.
that the defense takes is, at least, by suggestion, that was to, send the other side on a wild goose chase and, spend a lot of time, and that, during, that actually they might not have discovered that Dr. Swanson, that there was any real person.
Right, well, I don't think there's necessarily clear evidence to support that. I suppose, in the extreme, that's certainly a possibility. I think it could also very well be that this is a case back from the year 2005. I don't know what the extent of his notes were when he was deposed, but it could be, and then also, his theory isn't that he formally retained Dr. Swanson. His position is that I consulted with Ms. Perkovic, who in turn consulted with Mr. Swanson, who relayed information back. So his testimony isn't that he formally retained him. It was essentially that it was essentially through his co-counsel that he did so, and I think it would be reasonable over the course of many years. I'm sure this was one of many cases he had that, perhaps he didn't remember the name. I think that's also plausible. But regardless, they do now have the correct doctor, and we're now looking at whether or not that original post-conviction petition should stand. And so I think the real issue is whether or not, based on the new testimony of Ms. Perkovic and also Dr. Swanson, should we go back and reconsider that post-conviction petition? And what I would say is that the only things that were introduced were essentially the extent of the relationship between Dr. Swanson and Mr. Birch. And what it clarified was that, there was somewhat of an extenuated relationship, that basically he was not directly consulting with him. But the evidence also, I think, supports the trial court's finding that information about the case was relayed back to Dr. Swanson, that he looked at it, that he concluded that there was a brain injury as a result of the case. And after receiving that information, after consulting with the OBGYN, after the fact that he had 30 years experience as a criminal lawyer, that he had 3 prior cases related to these, he realized that really he had limited defense options in this case. The defendant had already provided statements to police and testimony indicating that no one else caused these injuries, that it wasn't some third party that caused the injuries.
Did Dr. Swanson indicate, and I can't recall this from reading the briefs, that he ever came to the trial, that he was physically at the trial? Because it seems to me that's something that Mr. Birch said, that he was at the trial.
I believe he did at some point, Your Honor, say that. I'm not sure if that was in the original deposition or the affidavit, but that does sound correct to me. I'm not sure the extent to which that's been disputed. I think, regardless, when it comes to the key issues, we haven't essentially gotten enough to really overturn that original post-conviction petition. I would just add briefly, I'd just like to briefly address my point that I don't think the Civil Rule 60B motion was the proper vehicle for the trial court to address this matter. As this court knows, that's a civil remedy, and this is a criminal case. Essentially, the defendant, following her appeals, challenging her original convictions. The proper way to handle that would have been through a post-conviction petition, and I really think that the trial court originally should have been required to consider it. I don't know to what extent that has bearing on this court's opinion, but I do think that the proper vehicle to bring it, especially based on the cases from other courts of appeals that I cited, I believe in the 2nd, 5th, 8th, and 10th districts, indicate that that would have been the proper way to bring the claim. To briefly close out, I'll point this court's attention back to the post-conviction petition and order from Judge Cross. And what it says, and I quote, is that while the opinion of Dr. Pleopies offers an alternate theory for the injury to this child, this court does not believe that defendant petitioner has met the standard to show ineffective assistance of counsel. The court does not find that trial court's performance was incompetent, nor that but for his incompetent performance, the outcome of the proceeding would have probably been different. This court cannot find that the testimony of defense neurologist without forensic experience would necessarily have convinced the jury of defendant's innocence. I think that's critical. This is a case that's been going on for 10 years. They've had an opportunity to proffer an expert. And even in light of the testimony of that expert, essentially what the trial court's saying, the way I read it, is that even if he had gone and consulted with this expert potentially, that would not be enough to overturn the decision. And this is an opinion that this court has reviewed on appeal. So they don't have evidence that's strong enough to essentially challenge that particular factual finding when it comes to the post-conviction petition. I think that's particularly critical when it comes to this case. I know that they filed a supplemental authority. I think that's the difference between this case and the supplemental authority that they filed. And the supplemental authority was a shaken baby case where there were alternate possible explanations that would have affected the outcome of the proceedings, but that in this case, you don't have a shaken baby case, you have a brain trauma case where there were limited options to present as a defense. Because there were limited options, Mr. Burge did the best he did by strongly cross-examining the witnesses. And for that reason, his assistance was not ineffective. If the court has any questions, I'd be glad to answer them. Thank you very much for your time.
Your Honors, I appreciate the opportunity to be able to argue this case before you. Initially, Honorable Judge Moore, to address your question as to what the testimony was about Dr. Swanson's availability during trial. Dr. Swanson, in his affidavit, says, "I did not attend the trial of Melissa Dovala. I did appear in the courthouse for one day to support my wife, but she requested that I leave. I was in the courthouse for less than 5 minutes, saw no testimony, nor did I have any discussions with my wife or Mr. Burge." Former Judge Burge testified.
Wait just a minute. He said he did not appear at the trial.
Correct.
He did come to the
Courthouse.
But he did not have any conversation with his wife or Judge Burge. But that his wife requested that he leave.
Yes.
How did that happen without any conversation? I'm not sure I understand.
He showed up outside to support his wife. Was gonna, come in to watch and support her. She said, "I don't want you here. Go." That was there was no discussion.
No substantive.
Right. No substantive discussion. Yes. The testimony of Mr. Burge was that he consulted with the neurologist throughout the trial, and I think this is really where the characterizations are quite different between the appellant and the appellee, where the appellee describes it as merely some inconsistencies. What we're talking about here are lies. We're talking about lies and misrepresentations and deceitfulness that all go in favor of Judge Burge. I mean, there's no other way around this. Judge Burge testifies in one of his affidavits that Laura Perkovic specifically told him that Dr. Swanson said this was cold-blooded murder. He didn't say this was inflicted injury. He specifically uses the term cold-blooded murder. When Ms. Perkovic is asked about this in her deposition, she says, "I would never use that word, first of all, personally, because it's unprofessional. And my ex-husband certainly wouldn't have, because again, he didn't look at it enough. Appellee attempts to distinguish brain trauma from shaken baby. First of all, shaken baby includes elements of brain trauma as well. And there was an alternative theory presented here, and that was through Dr. Pleopoulos, who did present a theory that, first of all, it did not happen within 4 hours of the death, that it happened within 24 hours, and that it was not necessarily, that it was not blunt force trauma, but compressive force that could have been caused by the 4-year-old that was left alone in the room with him at one point, where, and everyone refers to the statement that Ms. Dovala locked Mr. Burge into this theory. There were no, because she said that no one else was around the baby. Well, she also said that she didn't hurt the baby. And there's no direct evidence that, no one says that they ever saw her, ever act violently, ever yell, ever anything like that. No one says anything about that. So the fact that her initial response was, gosh, I can't think of anything, I don't know when this would have happened, when she's obviously devastated by that this child who is in her care has died. Everyone puts all of this stock on the fact that, well, there's no way to get around this. That's simply not true. There was a meritorious alternative theory put forward by the defense. Further, this, as the appellee has said, that, well, the issue of prejudice has already been determined, and therefore it's not up for debate. Well, the prejudice is, first of all, not at issue in this court, because you determined that the only issue on remand needed to be whether or not the unusual and extraordinary circumstances affected the reliability, the accuracy and reliability of the trial court's judgment. Further, immediately before, in the paragraph immediately preceding what the appellee cites, the Judge Cross says that Judge Burge, in his deposition, testified he consulted with a neurologist, Dr. Tom Watson, throughout the case, as well as an OBGYN.
And at that, I'm going to have to stop. The time has run out. Thank you very much. We will take the case under advisement and send you a copy of our written opinion when it is issued. And you may also find it on our website if you want to check it out. Thank you.
Thank you, Your Honor.